And welcome back to this week's edition of Conservative Arkansas Media. I'm your host, Paul Harrell. So, the last episode that we did, we talked a lot about the special session that I think now happened 3 weeks ago. We specifically were talking about the changes or the proposed changes to the Freedom of Information Act that failed, and then there were new changes. And so we talked with State Representative Wooten about those and what he thought the retroactive clause meant or what it didn't mean. And so that was very helpful. But I thought I would reach out to one of the key players behind the scenes, from what I can tell, somebody whose approval meant a lot in terms of whether or not the FOIA bill that did pass, whether it was going to fail or pass. Joey McCutchen had a lot to do with that. His opinion is very well respected by those when it comes to the access of information, from the government and what a journalist like me is going to have access to, or what you out there are going to have access to. So Joey McCutchen actually joins us now. He is an attorney and an expert on these issues. Joey, welcome to Conservative Arkansas Media, sir.
Well, thank you. Thanks for having me.
Absolutely. Yes, sir. So from where you sit, let's talk about what we did get. From where you sit, are you pleased with the changes to the Freedom of Information Act that we did get?
I can't say that I'm certainly from what it could have been, which would have gutted FOIA from a records standpoint. It was an improvement, but my concern is that I want to know when public dollars are being spent, and I want to know that I can go get that information and how much is being spent, and who's riding on government planes and all those types of things. So,
okay.
From that standpoint, I don't think that law does a lot for those two things. And
okay, well, so then let's talk about maybe like an alternate universe about how bad it could have been. Okay, so what was almost done to the freedom of people to have access to information of the government? I mean, it was. Is it correct to say that it was an attempt to gut the Freedom of Information Act?
From my point of view, it's absolutely correct. That's a correct characterization, and not using hyperbole, as some would say that folks who fought against this were trying to do. But when you allow the huge number of government agencies, state agencies, commissions, boards, and you're going to tell the people that they can't access those records while the sausage are being made, and you can only see the final product, that would gut for you. And then you take it a step further and you say, okay, if we CC our government lawyer, then the public's not going to get to see those records. We say that we anticipate litigation. You're not going to get to see those records. Those two provisions, if someone's trying to keep the government's business secret, then those two provisions would go a long way to gutting our ability to get records on a state level. And it would give the governor an immense amount of power. And I think that's something that our legislature should probably take into consideration, even though we have a popular governor.
What were your thoughts about the parts of the bill that we did get that attempted to address the security issue surrounding Governor Sarah Huckabee Sanders and her family? What were your thoughts on that?
Well, I mean, I think we all start from the standpoint that we want to protect Governor Sanders and her family and others, but I'm not sure. I've never been convinced that that's what this was all about. I think from my point of view, I think it's a smokescreen, and I think this was all about what started in the 2023 general session when Representative David Ray trotted out the same type of record gutting bill that would gut FOIA, and the legislature voted it down. You got to ask yourself, what's the emergency here? We've been abiding by this law for quite some time. This is no emergency. Uh, I tend to view it as politics, and but FOIA is not liberal, and it's not conservative, and it's not Republican, and it's not Democrat. It at its foundation, it's about our right to know, and therefore our freedom. And when we start chipping away at it, or under whether it's Representative Ray's bill or the governor's, or whoever's bill it was in the special session, the governor obviously was behind it. Uh, to me, it's a dangerous situation, and our republic is not safe.
Okay, so what about the argument? And just to be clear, and I said this last week, as a journalist, who in people in my profession, we kind of thrive off of the idea of being able to use a Freedom of Information Act request to get information, to report on it, to speak truth to power, and that sort of thing. So any change to the FOIA, I wasn't for, at least in the original form of the bill, kind of made the hairs stand up on the back of my neck and that sort of thing. But what about the argument that kind of came out? I don't know when the argument came out. The first I saw it was kind of in the middle of the debate of the special session, when things were not going as smoothly as anticipated. The House wasn't passing the rule change and that sort of thing. And so one of the arguments was that when the state is in litigation, okay, and you're an attorney, and so I really want your thoughts on this, that the state's in litigation trying to defend, let's say, a controversial law. Let's say it's a law in the future, okay, let's say that the next legislative session, the legislature succeeds in, making transing children, putting it under child abuse statutes. Okay, that's going to be a huge legislative battle. I keep talking about it. Let's say they succeed, and obviously the left's going to challenge that. And so in the court, so their argument is that the Freedom of Information Act was so liberal that basically leftist attorneys would be able to steal or see the legal strategies of the Attorney General's office when they're trying to defend controversial pieces of legislation. Is that true? Is that a danger? And if so, was this the right remedy for that? Obviously, I know you didn't support the bill, but is there a right remedy for it if it's true?
Well, the way I see it is it's not like you're dealing with a private lawyer versus a private lawyer, and you're dealing with the government, and so though there's a distinction. To me, there's a clear distinction, and that the people should be able to see that. And you throw out that example, but in 15 years, it's going to be another example that's going to cut against us conservatives. And so you can't say liberal versus conservative.
Right. So in my example, I'm citing the leftist attorney. You're right. To your point, we do need to think about living under the government, when conservatives potentially are not in control. So I see your point. So then it would be your position then that because it's like the Office of the Attorney General, that the privacy protections of legal strategies and things like that just aren't going to apply to a government office like that. I mean, that's your belief, right?
It is my belief. I think that's the way it should be, because you're dealing with the government. And again, it's all in the way these bills. It's the devil's in the details, right? I mean, and in anticipation of litigation, you can make that pretty broad if you want to, and so you've got to look at the wording. And when these bills hit the legislature, they're broad enough for a Mack truck to drive through, and that's concerning. And you can take a good, smart government lawyer and twist those words, and then we haven't even talked about the attorney fee provision that they wanted to make so onerous that that it would have a chilling effect on the public, you got to ask yourself, why are they? Why should we have to not only prevail, substantially prevail, but also have to show bad faith on the part of government? Uh, and then you basically have lawyers who won't get involved in these cases, unlike me, who has taken a hours upon hours doing free work, uh, which I'm glad to do that because I believe in FOIA. But to create a definition that is, I've got to not only win but show bad faith, or show that it was they didn't give us the records. For example, uh, they gave them to us. It wasn't arbitrary. Uh, that's so then that's the other way. There's no teeth in the law, and so people won't bring lawsuits to enforce their rights. And to me, that's just wrong.
Now, so that, just to be clear, was that in the original proposal, but it's not in the one that passed?
Correct.
Okay,
That's
so
correct.
my question to you is, I mean, I've seen a lot of general assemblies and special sessions come and go. I know you have as well. How pleased are you with the legislature's ability to represent their constituents in this way? I mean, they really held strong here against a lot of political pressure to go ahead and pass this. And I think the House specifically, just from where I sit, the House was kind of the toughest, the strongest body, of the two in terms of pushing back, in terms of waiting, in terms of saying, hey, look, we want to do something different. We want to take care of the governor's security. We want to make sure she's secure, but we don't want to do this. How impressed were you with their resolve to be really an independent body?
Well, I think when you see the House time after time fail to, and from what I understand, a group of freshmen who refused to suspend the rules but the bottom line is they were hearing from the people. Not only were they getting from the governor that she was going to primary them, and from what I heard, withhold the possibility of withholding funding to various causes, but they heard from the people. And when the people in essence revolted and said, we believe in our state's motto, then that's when the snowball effect started happening, because I talked to a lot of people before the session, and many of them were scared that they were going to get on the blacklist. But you had a few who stood up and said, this just isn't right. We believe in our right to know. And they took steps public steps and courageous steps to protect FOIA, even though they may pay a political price. And that's what was impressive. There were some I weren't impressed with at all, who I don't know what they think they were trying to conserve, but I wasn't impressed at all. And in fact, I won't mention names, but I was very disappointed in some of our legislators who call themselves conservatives, that they could get on board with this, and surprised that some that were very seasoned legislators would sign on to something, would become a sponsor before they even read the bill. And that's what I kept hearing over and over. Well, I really didn't know what I thought it was about security. I didn't know it was about this, and this.
Yeah.
Yeah.
Were you in the room the night that the Senate committee, I guess they heard from so many people showed up to testify. You were one of the ones that testified against as well on that night, correct?
Well, depending on which night you're talking about, the first night we waited all day to testify, and Senator Hester came in and said that they still weren't in a position. This was 7 o'clock at night or so. Still weren't in a position to have a hearing on the bill. And the disappointing thing about that is that we have a FOIA task force, which in essence, the sponsors of this bill thumb their nose at. And if we would have gone through that process and had that bill vetted, of course they knew what they were going to hear because it was so bad. But if this bill would have gone through, it had been transparent from the start, gone through the vetting process through the FOIA task force, folks who understand FOIA, understand how it's going to affect the people, and they disagree somewhat. I'm not for most task force, but
Well, I was going to say, it kind of makes me think that, okay, well, if other task force in the past didn't come to the predetermined conclusion that the people in the higher ups wanted them to, then we would have just ignored them. Just like we. So tell our listeners, though, tell our watchers, our viewers, rather, about this task force. So how did this task force on freedom of information come to be?
yeah, that's an excellent question. And I think it was 2000. I want to say 17, but it was a legislative enactment. I mean, the legislature enacted it, and in essence, uh, each of the major each of the constitutional officers will have an appointment. So they can choose someone to be on the task force. Uh, this so it's really not just a rubber stamp at all. And you see like you may see an appointment from a university. You may see a reporter as an appointment. Robert Steinbuck, who's the recognized FOIA expert, was on the task force. You might have a lawyer, like an excellent lawyer who's fought for FOIA, like John Toll. You may have someone who's a city attorney. So you can get a wide variety of perspectives. And but for the sponsors, again, both in the general 2023 legislative session, when they rush these bills out 2 weeks or so, one would have gutted open meetings and the other would have gutted open records. The open records uh, bill was rushed out right at the end, and really.
Well, and they also didn't they also try to tweak the open meetings law as well. I mean, this wasn't. I mean, I know they might have tried to do it earlier this year, but if memory serves, they've tried to do that in other legislative sessions and failed. Right, because there's this idea that the public officials claim that they can't ever talk about anything, without calling a meeting, and they're in violation of the meeting. They're saying that it's just basically too much of a burden or a high standard for them to meet it. But you're telling me that got shot down too, so the open meetings laws are intact, correct?
Not exactly.
Okay.
Our open meetings laws aren't anywhere close to being intact because the Supreme Court has in essence really created a situation where they're looking at case by case. And we don't have a strong open meetings law in Arkansas, but we can have one. And if this constitutional amendment is drafted correctly. And to me, that's the big discussion right now. And the huge news is that as we speak, we are looking at a constitutional amendment in Arkansas we'll see the devil's in the details, but what we can forever enshrine in our Constitution the strongest open meetings law and the strongest open records law in the country. And I've been working hard in that regard. I'm not on the drafting committee. The drafting committee is going to come out with their initial drafts shortly. I don't know if that's this week, next week. The people will get to comment, but the devil's in the details. But we have the ability, Paul, to create a very strong open records and open meeting law in Arkansas and put it in our Constitution.
Well,
And that's
it certainly is interesting times for sure. Back to the task force, though, I just wanted to reiterate. So the task force on freedom of information, they were not for the proposed bill that failed, and so I want to make sure that that is in fact the truth, right?
that is absolutely. They met again. This bill showed its ugly head on Friday before the session on Monday, and the task force met that morning. The sponsor of the bill did not show up. The task force stated in no uncertain terms that it was unanimously against this bill, and that it was and went a step further and said that it was bad for the people of Arkansas.
Wow, that's
that
normally, as you've pointed out, that doesn't really happen that much with task forces in the past. So here we are. I found that fascinating. So essentially, I mean, from what I can tell, I think we dodged a big bullet, right? I know you're probably not happy with exactly what eventually got passed, but it was certainly, in that the sausage making of legislating, certainly far superior. I mean, there's a lot of conservatives that kind of, took a victory lap because they were able to, only pass these changes in a limited way instead of these broad changes that would have really taken our rights away as citizens.
Make no mistake about it. It was a victory for the people, and the case could be made. Certainly, we all want security. To me, that's a limited exemption. I think it could have been drafted better. I think that it could have ensured that people like me who want to see how much a governor or anybody else, when they're using an airplane paid, a state-owned airplane, how much that's costing the taxpayers, how much, who's on that flight. I think we could have drafted a much better bill. But the bottom line is, it was a huge victory for the people that we got rid of the language we did. But we're not out of the woods yet. I mean, the ink hadn't dried on that bill before they were saying they were going to come back and run the probably do it again, whether it's the attorney-client privilege exemption or the deliberative process exemption. And that's the reason that we've been forced to proceed with a constitutional amendment.
Okay, so the constitutional amendment is essentially a response to, hearing people say they're going to continue at this till they get what they want, essentially. So, I mean, so the battle is definitely not. There's one battle that's been fought and won, but the war over this is going to continue. That's what you're saying?
That's part of what I'm saying. What I'm saying is this just didn't start with this special session. We had Representative Mary Bentley who brought an open meetings bill that said that 1/3 of our governing bodies can meet in secret and discuss and decide our business, our public business. So, do we want mass mandates or we don't want mass mandates? Whoever's governing body making that decision, 1/3 of them, if her bill would have passed, 1/3 of them would have been able to meet secretly and discuss and decide that. And guess what's going to happen next? One of those is going to meet with another group. And I mean, it wasn't a tweaking of open meetings that Representative Bentley brought. It was a gutting of open meetings. I mean, can you imagine if let's just say there's 12 quorum court members, 1/3 of them, 4 of them could have met secretly, then one could have met with another 3. I mean, it was
and what you're describing is a sinister manipulation of the law, but we have to assume. I mean, you have to assume that that's what politicians will do with it, because if they're given the legal authority to do something, they do it. That's just human nature, right? So yeah, I see your point. A third can meet, and then another third can meet, and eventually the whole group has made a decision without the public ever knowing about it. And so that certainly is the danger there. Attorney, I'll give you the last word. Go ahead.
Well, not only has the legislature proposed bills like that in terms of open meetings, but the Supreme Court has really done us no favors in that regard, either on a case-by-case basis. But I encourage folks to participate in the comment section of this constitutional amendment that's coming up. I think it could enshrine FOIA and make us Arkansas an example of what literally what the strongest example of open government is in the country. We have a great opportunity, or not. Again, it's going to be all in the drafting.
Joey McCutchen, thank you so much for coming on Conservative Arkansas Media. We really do appreciate it.
Thank you. Appreciate it.
Yes, sir. Folks, that's all the time we have for this week. We really appreciate you watching. Share this video. Tell your friends about it. Again, thanks to Joey McCutchen, and we'll see you next time.